Objection, same grounds.
Sustained.
I have a money.
Okay.
Please make sure we're keeping the record. Thank you. I'm good now, thank you.
Is Exhibit 25 an email from Jonathan Russell to Donald Sather regarding the email I had sent the city about your notice?
I'm sorry, did we address exhibit 24?
I'm not hearing any
20.
evidence.
Yes, so that's
25, no, 25, is that correct?
Yes. So isn't that an email from Jonathan Russell to Donald Sather from the email that I sent regarding your petition? Yes.
objection, same grounds. Over. For 25? She removed 24, she skipped 24 to ask about it. She said she removed that one, so I think we're on 25 now.
Yes.
Is there something we're showing that? This is
25.
This is just a petition to appeal, right?
Well, it shows that the email from our office regarding our representation of the L Hotel and Mr. Abdo was then sent from city manager Mr. Russell to then mayor
I
Mr.
removed
Donald
that.
Sather.
Okay.
Just hard to keep up.
Can you direct your attention to exhibit 29, 30, 31, 32?
Objection. I believe that you're seeing pictures of another property owner's home.
It's not a
So
home,
that's sustained.
it's not a home, it's a business that's right beside that's operating with no permits whatsoever.
That's no-
Objection is sustained.
And it's being advertised on the city of Washington's website as a business that has no permits that are operating right beside Mr. Abdo's.
That objection has been sustained.
That would be our exhibits. I just would ask for closing.
Okay, thank you.
Before you do that, I recommend that those exhibits that were objected to and sustained, be removed from the zone. If you want to keep them in there, just make, we need to make it be clear for the record which ones were not considered.
Well, I was given 30 minutes, but I don't have any new evidence to present. I was just gonna go through here, especially for clerk, if I may. Exhibit 1 was,
Yeah, I think you have 30 minutes to talk.
exhibit 1 was sustained, so it's not part of the record. Exhibit 2 was entered, so that is part of the record. Exhibit 3 was sustained, so that's not part of the record. 4 was sustained, not part of the record.
Five also sustained, five,
5
six,
sustained, not part of the record.
5, 6, 7, 8 were sustained, 9 sustained.
Okay, slow down. Let's just do the best.
Oh, I'm sorry.
Please, where you at? 9. Nine was sustained. 10 was sustained. 11 was sustained. 12 was sustained. 13 sustained. Sustained, 15 sustained, 16 sustained, 17 sustained, 18 sustained, 19 was, 19 was in. 20 was not presented, was not part of the record. 21 was, entered, so that was presented. 22 is sustained. 23 was sustained. 24 was removed. So it's not part of the record. Not presented. 25 was allowed. Without objection. 28 was not presented. correct me if I'm wrong, you didn't present 31.
I
Property tax
refer
part.
to 29 through 34 as a collaborative to prove that the neighboring properties operating illegally in the city is aware. He's not done anything about it, and he's a current city councilman, but we want to punish Ms. Bradley.
I believe that was sustained. 32, are you moving? 32 is sustained. 33 is sustained. Yes, ma'am. Thank you for your indulgence. I don't have any evidence, I'm just prepared to do a closing.
Okay. All right, we have, closing statements by each side, so Ms. Posey will start with you.
Thank you, I appreciate you letting us sit at the tables, it's much more comfortable. Thank you, Chairman and members of this board, for the time and effort that you've put into this matter. It's been since August of last year, a long hearing and a couple other settings, and I just want to thank you for your service, and it's above and beyond the call of your duty, and so thank you for that. At the outset, just like I said in my opening statement, I would like to again say, in my opinion, this is not a referendum on the popularity, profitability, or success of the El Hotel. This hearing is about whether or not the actual use, advertising, and marketing of the El Hotel violated the special use permit that you granted Ms. Bravo, and whether or not the manner in which she has actually used her property violates the special use permit and the zoning regulations for bed and breakfast. Ms. Bravo acquired 1040 North Market Street in 2021. The property at that time and now is located in the city's R9S zone classification. As you know, for every zoning classification, there are permitted uses. Permitted uses are uses that the property owner has an unqualified right to use without any permission whatsoever. For some zoning classifications like R9S, there are additional uses that the property can apply to you for a special use permit to allow them to use their property if it's allowed by the zoning ordinance. And it's possible for you to put conditions on those special use permits. A property owner is prohibited by law from using their property for a use that is not specifically permitted or a use that is inconsistent with the special use permit and any conditions imposed on that permit. These zoning regulations are not just pieces of paper and words, they're laws. Just like the laws of the state of North Carolina, federal laws, they are laws. We call them ordinances, but they are laws. They're codified in our city code, and you're obligated to enforce them. In 2021 and now, the bed and breakfast use was not a permitted use in the R9S zoning classification. However, it is allowed if you granted a special use permit, and on July 15, 2021, you granted Ms. Bravo a special use permit to operate a bed and breakfast at 1040 North Market Street. The definition back in 2021 of a bed and breakfast was very short and very simple. That definition was a quote, a private home offering bed and breakfast accommodations to 12 or fewer persons per night for a period of less than 1 week. Like I said, it's very short and simple. Absolutely nowhere in that definition does it mention, reference, or even infer to any type of events, indoor or outdoor whatsoever. In my opinion, it's incomprehensible and disingenuous to suggest that this definition contemplated the opportunity to provide any type of events at 1040 North Market Street beyond overnight accommodations for up to 12 people. The definition simply contemplated the common layman's understanding of a bed and breakfast where you and someone else reserve a room, stay a night or two, get up in the morning and have breakfast. You added conditions to Ms. Bravo's special use permit. First, you required a site plan to be submitted and approved by the technical review committee, including on-site parking requirements of 2 spaces for the dwelling unit, 1 per bedroom, and no more than 2 spaces in the front yard. Ms. Bravo did not submit a site plan or obtain approval from the TRC committee.
Objection.
Second, you required the dwelling to be owner-occupied. You received evidence, although it's been controverted, you received evidence that this condition was not met either. Those conditions clearly do not in any way contemplate an indoor or outdoor event. In her application for the special use permit, Ms. Bravo stated, among other things, 1, 1040 North Market Street was her home. 2, she would provide 4 bedrooms offering overnight accommodations and suitable parking for guests and any staff. 3, she would be the only on-site staff present and breakfast would be provided. 4, common areas would be available for social interaction. 5, all parking and driveways would be located in a safe and convenient manner. 5, adequate parking was available on the property for guests and staff. 6, the proposed use would not aggravate or create hazards for vehicles or pedestrians, both off-site and on-site. These are the words she used in the application she provided to you. I'm not embellishing any of those words. That's what her application says. The Board of Adjustment minutes from July 15, 2021, when you approved her application, reflect she clearly stated, among other things. 1, she was requesting to operate a bed and breakfast. There's absolutely no mention by her of indoor or outdoor events. 2, she would only have 4 guest rooms. 3, she'd be the primary innkeeper living on site in the first floor master bedroom suite. I'm not embellishing any of that either. That comes directly from your minutes. During the meeting on July 15, 2021, Chairman Fuchs asked Ms. Bravo some questions, and she answered those. In answering Chairman Fuchs' questions, Ms. Bravo said there would be a maximum of 4 couples, 8 total persons, including a family suite for 2 children, with a maximum guest capacity of 10 guests. Ms. Bravo answered questions from Board of Adjustment member Mr. White. Ms. Bravo told Mr. White that there was enough parking on her property, including a 2-car garage, a long driveway, and a carport. She indicated to Mr. White that there would be no food service for non-guests. All of the above that I just went through is contained in the city's application for revocation of the special use permit. And that application was admitted into evidence by you in August. And then, during the hearing, you received evidence concerning all of the above that I just stated. So you can see Ms. Bravo is not utilizing 1040 North Market Street in conformity with her representations, the special use permit you issued, or the city's zoning regulations. In May of 2024, in response to illegal activities of another bed and breakfast in the city limits, including activities that were not allowed under the 2021 bed and breakfast definition, the city decided to amend the city code to clarify what should have already been clearly understood by the operator of the bed and breakfast. And it was also a compromise to allow those operators to do more after that amendment was passed than they were allowed to do under the 2021 definition. So in May 2024, the city added 2 uses to its zoning code. One was a private event center indoor, and 2 was a private event space outdoor. If you go to the zoning code, there's a grid. And all the uses, all the potential uses throughout the city are on your left-hand side. And then all the zoning classifications are on the top. And you go through that grid, and they're squares, you meet squares. And when you do that, you'll find that, and if the square has a P in it, it's permitted. If the square has an S in it, it's a special use permit. And if there's nothing in that square, you can't do it. So, the private event center indoor and private event center outdoor was defined in the Woodland zoning code in 2024, and neither of those are permitted uses or allowed by special use permit in the R9S zoning district. Again, these changes were made because of a lot of complaints from citizens who were living around bed and breakfasts that were doing things that disturbed them late at night, noise, traffic, etc. By virtue of the 2024 amendment, the simple definition I told you at the beginning was expanded to, quote, an owner-occupied single-family dwelling offering overnight accommodations for transient guests for periods of less than 1 week. The occupancy is limited to 12 guests per night. The character of the dwelling must be maintained. Signs must be in compliance with the city code. The business cannot sell merchandise or other meals on the premises or employ more than one part-time dedicated staff. Services can be held, this is the key part, exclusively for overnight occupancy guests, with an allowance of 1 additional person per guest, up to a maximum of 24. Outdoor events are not allowed. Period, end quote. So on a given night, if a bed and breakfast had 8 overnight guests, as Ms. Bravo represented to you, she would have the most, 8. Then you could have 8 overnight guests for a total of 16 people for some type of event service inside the building, inside the home. If you had more than that, you had 12, you could have 12 overnight guests, and you could have up to 24. But that's the limit, that's the ceiling, and that's more than is accommodated at the El Hotel. Again, this was a compromise, that 2024 ordinance amendment. It allowed bed and breakfast operators to do more than they were allowed to do in 2021. Ms. Bravo's argument is that the 2024 amendment took something away from her. Nothing was taken away. She was given more, the opportunity to do more than she was previously. As said in the city's application for revocation, which was admitted into evidence and supported by evidence that you heard in August, Ms. Bravo has used and marketed and continues to use and market 1040 Market Street in the following manner that is not permitted by the property's R9S zoning classification. 1, private indoor only event services that are not held exclusively for overnight occupancy guests. 2, private indoor only event services that exceed 1 additional person per overnight guest. If you exceed those, that's beyond the limits of the zoning regulation. 3, private event center indoor for private functions such as banquets, weddings, anniversaries, receptions, and other similar celebrations are not permitted in the R9S zoning classification. Whether you like that or not, or agree with it or not, that's what the law is. 4, private event center space outdoor for private functions such as banquets, weddings, anniversaries, receptions, and similar celebrations. Again, specifically prohibited in the R9S zoning classification. The El Hotel website advertises and continues to advertise, among other things, quote, an event space that, quote, can accommodate up to 50 guests. It's not permitted in the R9S zoning classification. The El Hotel website advertised and continues to advertise, among other things, an intimate venue for weddings, accommodating up to 50 guests and providing both indoor and outdoor spaces for seamless ceremony and reception experience. Again, that's not permitted in the R9S zoning classification. 7, the El Hotel advertises, among other things, on-site accommodations for up to 16 guests, not 12, not 8, 16. That's not permitted in the R9S zoning classification. The El Hotel website included of outdoor wedding ceremonies. That's not permitted in R9 as zoning classification. 9, sign on the property states, quote, El Hotel. A hotel is not permitted in the R9 as zoning classification. 10, the bed and breakfast operated on the property is not owner occupied. That's our contention, as required by the city code and special use permit. The pertinent definition of occupied is to reside. 11, on June 14, 2025, there was a commercial, after the first notice of violation, a commercial, paid for, third-party event for more than 24 people that was held on the property in violation of both the R9S zoning classification and the special use permit for the property. And they admitted that during their evidence. Again, all evidence of these violations was presented to you at the August hearing. In addition, when you have a special use permit, you also have to abide by the general criteria in the zoning regulations. And we presented to you at the beginning that there were several violations of the general criteria, and then we presented evidence of those. Those include, number 1, the proposed use will not adversely affect the health and safety of residents. 2, the proposed use will not be detrimental to the use of or development of adjacent properties or other neighborhood uses. Number 3, the proposed use will not constitute a nuisance or fire hazard because of the number of persons who will attend or use such facility, the vehicular movement, noise, fumes, and other types of physical activities. 4, the proposed use will comply with all additional specific criteria, which we have shown it does not. 5, the proposed use will not create or aggravate hazards to vehicular or pedestrian traffic on roads, sidewalks, both off-site and on-site, serving the proposed use as determined by the size, capacity, condition of those side roads and sidewalks. Number 6, the proposed use will be compatible with existing uses that are adjacent to or neighboring the proposed location. Number 7, the bed and breakfast is not owner occupied. Again, the evidence you received in August confirmed the above violations of the general criteria for the special use permit. As you can see by the letter that was admitted into evidence on April 16th and discussed briefly tonight, the city did tell Ms. Bravo that they had received several complaints from citizens. Asked her who resided there as the owner operator and indicated the Board of Adjustment could revoke her permit and invited her to discuss this with the planning department. By email, Ms. Bravo replied, it was owner or operated, occupied on a daily basis. Pretty consistent with the testimony that she gave when she received repeated questions about that. Also, as part of your evidence, the city sent Ms. Bravo a courtesy zoning notification dated May 5th, saying the city had received several citizen complaints concerning frequent gatherings. It is your responsibility to address these complaints, and it is our concern that you may be in violation of the ordinance. Upon review of your website, this is in the letter, the courtesy letter, it was discovered that you were advertising back in May of 2025. It was discovered that you were advertising to accommodate up to 50 people for events. That's more than 24. Please take notice that your property is located in the R9S zoning district. Events for hire, private event centers, commercial uses are not permitted in residential zoning districts. This correspondence is intended to serve as a courtesy notification that events are not allowed under the bed and breakfast definition and should cease. Please contact us if you want to talk about it. Also admitted into the evidence was the city's notice of zoning violations, the first one. We've gone over that. Those are the first 10 violations that I read to you just a minute ago. We gave Ms. Bravo 30 days to correct those violations and invited her to discuss these matters for an amicable and timely resolution. Usually when the city informs people of zoning violations and use violations, like Elmwood Bed and Breakfast, they come into conformity with the zoning regulations. They stop violating the zoning regulations. The second notice of violation was dated June 23rd. It's basically the same as the first. However, it added an additional paragraph, which was that event that had over 24 people inside and outside. That letter contained a picture of the event, and that letter was also in the city's application for revocation and was admitted into your evidence. Also contained in the evidence presented to you were minutes from the City Council's meeting on May 12, 2025. May 12, 2025, during which 3 individuals, Mike Kelly, Deborah Spear, and Ray Faulkner, complained to the City Council about the events that were being held at the El Hotel. You also received evidence from the general warranty deed through which Ms. Bravo acquired 111 Jackson Street. On the face of that deed, she listed her address as 111 Jackson Street, not 1040 North Market. You also have evidence that was presented to you that contained her typewritten remarks to the City Council concerning the plans for the 15th Street redesign. In her typewritten remarks, she states she's the homeowner of 111 Jackson Street and business owner of 1040 North Market Street. You also received 20 or so pages of evidence that were copies of the El Hotel website, social media, and pictures. On those pages you can see El Hotel advertised for up to 50 guests, bridal showers, anniversary parties, book club luncheons, business meetings, rehearsal dinners, and baby showers. There's a picture from a wedding that says, "Come host your wedding with us." There was and is a page that discusses rehearsal dinners with 5 guest rooms, accommodating up to 50 guests. That's more than 8. It's definitely more than 12. There's a post from May 5, 2025 with a picture of a wedding and comments about the wedding held there. Again, it's advertised as a hotel. It's also admitted into evidence are pictures taken of 11th Street. 11th Street is a side street on the North Market, as you know. And these pictures show the nighttime pictures of cars parked on each side of the street and how difficult it appears it would be to get through that street. You also received evidence, which were sections of the North Carolina Fire Code, and you received evidence from the city's fire chief concerning how the parking on the El Hotel violated sections of the North Carolina Fire Code, including, most importantly, the inability of emergency fire apparatus to access 11th Street. You also heard testimony from the city's then interim planning director, Dominique Cunningham. That was really telling testimony. He stated, among other things, 1, a private event center indoor is not permitted in the R9S zoning classification. 2, a private event center outdoor is not a permitted use in the R9S zoning classification. 3, neither a private event center indoor nor a private event center outdoor is permitted by a special use permit in the R9S zoning classification. 4, a private indoor only event held at 1040 North Market Street as a commercial event was not exclusively for overnight guests and therefore is not allowed in the R9S zoning classification. 5, a private indoor only event for over 24 people is not permitted in the R9S zoning classification. 6, private outdoor events are prohibited. 7, the El Hotel is not allowed to accommodate up to 50 people under the city's zoning code. 8, the El Hotel is not allowed by the city's zoning code to host a wedding event, including a wedding event accommodating up to 50 people. 10, the outside wedding ceremonies and hotels are not permitted in the R9S zoning classification. 11, the planning definition of occupy, and he's the planner, so he's asked, what is the definition of occupy? And his definitions, he said the planning definition of occupy is someone who resides at the address and stays there overnight on a regular basis. On June 14, 2025, there was a commercial paid-for event that violated the R9S zoning classification. 13, in his opinion, it is detrimental to neighboring properties when the El Hotel operates outside the scope of the bed and breakfast definition in our zoning ordinance. 14, the use of the El Hotel escalates to the scale of a nuisance because of the number of persons in vehicular movement. 15, the use of the El Hotel is not compatible with the existing uses that are adjacent to or neighboring 1040 North Market Street. 16, North Market Street is not owner-occupied based on the testimonies or the witness statements or from excerpts from city council meetings. 17, the 10 statements in the city's first notice of zoning violations constitute zoning violations as well as violations of the special use permit. This is from the planning director. The manner in which the El Hotel is currently advertised and used violates the general criteria of the city's zoning ordinance. The evidence presented by Ms. Alligood on behalf of Ms. Bravo confirmed that Ms. Bravo violated the zoning ordinance regulations as well as her special use permit. Her witness, Susan Kellum, who at one point was asked to step down, admitted that there were over 40 people at the event that she attended. During Ms. Bravo's testimony, she admitted, one, she hosted a wedding in October of 2022. She hosted weddings in 2023. She hosted bridal showers, baby showers, anniversary parties, and those type of events in 2024. She indicated that, on average, for those type of events, she hosted from 20 to 30 people. Ms. Alligood has attempted to make constitutional arguments concerning this case. I would suggest to you that those arguments are smoke and mirrors and irrelevant to your decision. The constitutional arguments are the subject of a federal lawsuit Ms. Bravo brought against the city, in which she has claimed over $1 million in damages, plus attorney's fees. Ironically, if the city's bed and breakfast ordinance is unconstitutional and stricken, she would have no basis to operate a bed and breakfast on any scale whatsoever. Despite what you have heard, I would suggest to you this is not a zero-sum game, meaning it's not all or nothing. If you revoke Ms. Bravo's special use permit, I understand that she can still operate an Airbnb using her bedrooms, not for events, but an Airbnb. In conclusion, I would like to emphasize again, this is not a referendum on popularity, profitability, or success. And I said that because last time, council chambers were full of people. It was a very contentious environment, and I was very uncomfortable. And it seems to be, for some reason, a different environment tonight. Your decisions about whether or not the actual use, advertising, and marketing of the El Hotel violates the special use permit you granted her, and whether or not it violates the zoning regulations for bed and breakfast. You received ample evidence, most of which I have now summarized, and I thank you for your patience. I'm sorry I took so long, but I wanted to hit everything that you were told you would hear, hit it, confirm that you did hear it, and then remind you that you did. It's been a long time since August. For the reasons that I've stated tonight, I think you have a very simple, easy decision, and that decision is to revoke the special use permit that you issued.
Ms. Alligood,
Yes.
be sure to speak into the microphone, please. Thank you.
I would like to start off by saying first that I am not litigating a federal lawsuit, I'm aware. But everything that I'm about to discuss is the exact same thing that I discussed in August. My position today is stronger than it was in August. Mr. Holscher wants to say that your job is to review the evidence to see if the special use permit has been violated. But while doing that, you're supposed to ignore the violations of her constitutional rights that have taken place. Let me direct you back to the April or the August meeting when the city called Detective Dolly to testify about a vehicle and its whereabouts. And when asked about that, he gave several dates of where a vehicle was. And he testified that he did it at the direction of the mayor. And in his extensive career with the City of Washington Police Department, he has never had to do that for any other case. it shouldn't be taken. Federal law and state law, equal protection clause, everyone is supposed to be treated equally. Everyone. Not singled out for who you are, what you do, what you wear, the color of your skin, your profession, how tall you are, how short you are. Everyone is supposed to be treated the same. And there's been ample evidence to support that Ms. Bravo hasn't been treated the same. The city is trying so hard, and I would be right in Mr. Holter's shoes, trying to keep out all of this information. Why? Because it puts the city at a liability. The neighboring property to the El Hotel is operating as a wedding venue and has been.
Facts on that. No evidence supports this part of the argument.
That's not true. It was mentioned in the August meeting. No permits. None. Nothing. The city is aware. And when asked, the city asked, well, we know, but we're not going to do anything. Is that fair? The neighboring property that shares Jackson Street, or not Jackson Street, 11th Street, where there's been complaints, allegedly, about parking. But again, the city's witnesses couldn't stand
Objection,
here.
facts not in
The
evidence.
city's witnesses couldn't stand up here and say they watched every vehicle on that street go into the El Hotel. Why is the city trying to hide it? Because he's a current council member. Why is he getting favoritism? The ordinance change, as we indicated in August, is a clear violation of every statute, state law, and federal law that there is. Council for the city has even indicated that in some of the emails that he fought so hard to keep out. I would too. The Senate Bill 382 that I mentioned in August exactly refers to this ordinance change about downzoning, reducing the opportunities that you're allowed to do with the permit. It's applicable. North Carolina General Statute says that the ordinance is then unenforceable and void. But if we don't care about our constitutional rights, we'll throw that out the door. As far as the definitions in the ordinance, Mr. Holscher read those off. And I believe he indicated that Mr. Cunningham stated what his definition as the interim planning director was for occupied. And I specifically asked Mr. Cunningham in August, why is your definition different than the city of Washington's ordinance? No response. Mike Dale, Donald Sapper, Jonathan Russell, Dominique Cunningham, and Stacy Graythorpe. What do they all have in common? They're no longer here. But their names have been mentioned quite a bit in this case. Very coincidental. The documents that you received in August, as Mr. Holter indicated, the first notice, courtesy notice, was sent April 16th. You saw in the documents that the city did not turn over as requested, understand why, indicates that Ms. Bravo responded appropriately to that letter. Email did suffice, and that she did, and you have that in evidence. The next notice, the courtesy notice, that came on May the 5th, stated that there was an issue with the fence because there's been city complaints about parking. The city council meeting wasn't until a week later, on May the 12th, well, where allegedly 3 people came forward and complained. So how was the city able to send a letter on May the 5th alleging violations for something that they allegedly didn't become aware of until a week later? Well, when you want to make stuff up,
Objection.
It's my closing argument, and I am
Those
referring
are-
to the information that I have presented into evidence, and like you said,
That's not in evidence. The objection was sustained, that's the evidence.
I'm referring to it being politically motivated, where I discussed that in
Just saying.
detail in August.
Then change the way you reference it.
It is clear, since day one, that that is what has taken place. The issue allegedly, again, was about it being owner or operator occupied. Definition did not say that you had to live at the residence. There's been mention of, she indicated that she was a business owner at 1040 North Market Street and a homeowner at 111 Jackson Street. Both of those statements are true. You can be a homeowner and a business owner. So, because she's both, does that mean that she's not living there? No. Again, these violations, the one sent on June the 2nd, that Mr. Holster said, we send these and then we give 30 days to work with the city and become amicable to give them opportunity. The exhibit presented tonight showed that she was calling the city, leaving voicemails, sending emails. But the city,
Objection is a mischaracterization of evidence.
the city then had to make sure everybody's on the same page. Our lies gotta be right. We gotta make sure our lies are correct before we reach back out to her. But let's not wait 30 days. Let's send her another
Objection.
on
We
June
cannot
23rd.
continue to allow Ms. Allinger to refer to evidence that is not admitted, and specifically when an objection was made, it was sustained.
The second notice was sent on June 23rd. They don't teach math in law school, but from June 2nd to June 23rd is not 30 days. But yet she was treated fairly. She was given the same opportunity as all the others. Again, this is such an issue, she's such a detriment to the city. She's a terrible person. City can't even sign their own application to revoke her permit. Such a detriment. If you notice that all the members who signed the document from the letters, no longer with the city, coincidental. 2 members of the current board approved her permit back in 2021. Again, as I stated in August, the definition wasn't clear. Couldn't say that she's gonna have events, how many people she had to stay there. None of that was included. Today, there is still a lot of gray in the ordinance. She wasn't providing notice of the change. None of the Airbnb.
Objection. Mischaracterization. The entire public was given notification of the ordinance, the proposed ordinance amendment change before it went to the planning board, and the entire public was given public notice of the change before it came before city council.
Okay, I presented evidence from Ms. Bravo and other members that they did not receive notice. So again,
It's
this
a
is
public
my
notice.
closing
It's in the
argument.
newspaper. You don't send notice to every resident in the city when you make an ordinance change.
Well, pursuant to the city ordinances there is that if a change affects an individual or business, they have to provide a notice. So now are you saying that the city violated her rights again?
That's not true.
Okay, well, can I please continue with my closing argument? I have to give it to the city, they're trying hard, I would be too. Again, it's interesting that the city is advertising for a business that has no permits. That fair treatment? Alleged safety concerns. I get to hear one. I get to hear an evidence that presents that there is a safety concern. It's a public street. We all can go park right there on that public street. There's nothing anybody can do. You can't be cited for it. It's a public street. Again, none of their witnesses stood here and said that they physically watched all of those vehicles, occupants, walk straight into the L Hotel. If it was a private road, a little different. It's a public we were here in August, and we held this open, there was requirements that Ms. Bravo was supposed to do, not have any violations. She hasn't. It's been longer than 4 months now, and almost a year.
Objection, irrelevant.
In almost a year, she's had no violations.
Objection, irrelevant, and there's no evidence, one way or the other, whether there's been any violations. The purpose of this hearing is to decide whether or not she violated her special use permit.
Mr. Chair, I recommend that, because there's no evidence of any violations or non-violations at all on the record, none. And you're entitled to argue, but make an argument, the board doesn't have to accept it.
Well, I'll continue with my argument. No violations took place. It's been almost 8 months. She was also supposed to reach out to the city within 30 days to try to come up with an amendment to the ordinance. She reached out. She was told nothing was gonna change. Again, those members are no longer with the city.
Again, I'm gonna interject something here. We talked about this already, not before everybody else, but the reason this was tabled was to give an opportunity that whether anything happened during this 8-month period is irrelevant to whether violations occurred or give rise to a revocation of special use permit. It's sort of like trying to bring into evidence the mediated settlement conference, what happened or didn't happen, and say somebody did argue good faith. You're not allowed to raise that issue at all, or in fact, to be sanctioned for it. This doesn't have the restrictions that the court would have, or the judge would have. But it's, in my opinion, as an attorney, it's improper to bring those up as an issue because they don't have anything to do with what this board was addressing back in August. This was an opportunity, whether it was taken advantage of or not, or whether the city responded, or whether Ms. Bravo did what she was supposed to do, which this board didn't obligate her to do that at all. And she could choose not to. But the point is, it had nothing to do with what was in front of the board last August when this thing came up. So it was just an opportunity maybe to have something like a text amendment or some other way of trying to resolve an issue. But it's not relevant to this board. I'm going to tell them not to consider it.
Well, respectfully, I disagree because.
I understand, but that's
in
it.
a court proceeding, if there any evidence that has, or
What-
information that's on the
What I'm saying to you is that that's the end of that. This board is, I'm instructing them as a lawyer not to consider anything to do with what happened in this 8-month period between now and then. And they should not consider, shouldn't let you go on and argue about that. Yeah, because they've been fairly lenient about arguing because the judge is instructed. Closing arguments are just arguments. That's all they are, and lawyers take a lot of leeway in making those arguments. But you can't argue about something like that, not you.
Well, again, what has been in question was her ability or involvement with engaging in the city. And you've seen that she has done that since day one, and she has tried to do that since August, and she's been told nothing's going to change, and the city has not engaged her. I think that is important. It goes to the initial issue that we have stated since day one, that they don't have any interest in working with her. So the fact that she is trying to make a change, she is trying to get the ordinance where it's supposed to be, she's putting in all this effort, is important for this board to know and making a decision. Nobody can continue to do something if the person in charge says no. So how is that her fault when the city is not allowing anything to take place? Why is she going to be punished for it? And that was specifically questions again that were asked. What efforts have you made? She's putting in all the effort. The city is the one that is not allowing her. So it's important.
I'm going to say this again. The questions they asked had to do with that time in August. What had she done between the time she got the violations or got some kind of notice of it to the point we had this hearing back in August? Everything that happened after that had absolutely nothing to do with their question. They haven't asked a single question of anybody tonight about what happened since August. Not one. And so you're raising matters that are not before this board and should not be before the board, and they shouldn't even consider. They can ignore the lawyers, some people do, that's my recommendation. I think that you should move on.
Again, as you saw by the exhibits tonight, that Ms. Bravo has made efforts since day one, and the city has tried with everything they have to keep that out
Objection, there are no exhibits entered into tonight
Exhibit
That's
2,
support.
19, 21, and 25 show
Those
her
exhibits
attempt.
are attempts, but you went on to say, the exhibits say what the city did or did not do. Those are not admitted into evidence, whether they say that or not.
That wasn't what I was gonna say.
It already came out of your mouth, I already said it.
No, I indicated that they have been held the information that shows she made efforts to paint her as somebody that doesn't care, and those were my exact words in August. That's what the city keeps trying to do. And make it, and Mr. Holter, she's suing the city for $1 million. If your constitutional rights were violated, when you want something to be done about it, maybe she's taking a stand for the city and standing up against the city because some of our other residents in the community don't have that courage. But yet the city wants to paint her as a bad person. She has tried to get it right, and the city has refused. That's on the city. Issues of parking, they haven't proved any evidence. Issues of whether or not it's owner occupied, because she's stating that she's a homeowner and a business owner, I guess that indicates that you don't stay there. No evidence to support that. Issues about events. Again, in the ordinance for the permit that she was granted based on the city of Washington's ordinance at the time, there was nothing that said absolutely no events at all. None. So how are we gonna limit something that's not in there? If she didn't have a permit and she threw a graduation party like her neighbor did, is that a violation?
Graduation party is not a commercial use. The zoning code does prohibit commercial uses in residential areas.
I just said that if she didn't have a business and she held a graduation party as a private citizen, would
I
that
said
be
that'd
a
be fine.
violation?
Before that, you were saying it was okay for her to have these commercial uses because the zoning code didn't say you couldn't. The zoning code says you cannot.
That doesn't matter.
Again, there has been clear evidence that the city has tried to put together all of these things to try to stop Ms. Bravo. Clear. And I hope she doesn't give up. Because the city actually deserves that, the residents do. They failed to prove their case, they failed to prove that her permit should be revoked. That's what happens when you fabricate evidence. And so for those reasons, I would ask that you deny their application to revoke the special use permit, and that you approve or appeal of the violations and deny that there was any violations. Again, this is a business that's thriving. And I ask that y'all put all the news and everything to the side, and you make a decision based on what's in front of you. Because if the shoes were turned and you were sitting down here, that's what you would ask them to do, and you would hope that they would do. And that's what Ms. Brad was asking you to do.
Thank you, Ms. Allen.
Before there's any further discussion amongst the board members or emotions, I thought about saying this before they argue, but judges will instruct juries when they're making a decision, when they consider closing arguments. They're just arguments, they're not evidence. So the arguments of counsel, based on the evidence presented, if you're the sole judge of whether that evidence was in the record or away from that evidence. These guys are not. They're just making arguments. So if you believe that there is evidence to support those arguments, then maybe you consider the argument. But you're not going to consider matters that are outside the record in your consideration, regardless of whether they're arguing. They don't get any evidence, just what they are. So if you believe that they weren't
this time, I'll ask for any questions, comments, or concerns that the board would like to bring to light before I ask for a motion. Yeah. Okay.
It was my recollection that in August, there was a 4-month delay so that the 4 bed and breakfasts in the city, or wherever they were, to get together and come up with a new, sort of a different definition of what a board of bed and breakfast was. I haven't heard anything about that this time.
That's
And I just wondered what happened to that. And I thought,
Ms. Denise, I tried to give you an answer to that, and I was not allowed. And that, again, was part of my argument that I felt it was important for the board, to hear that information. But I tried to give you that information to answer your question, but I was not allowed.
The reason for this, this board has no control over what happens outside between the city and Ms. Bravo at all. And so the point was, and I think the board was reluctant to decide on this issue at that time anyway, and so I recommended, so that you wouldn't have to decide that night, that you table it for a few months to see if they can get together on this issue. Then it will continue again, I guess in December. And so it's been 8 months and nothing's happened. So back to the status quo where you were in August, nothing new is happening here. And you wouldn't be considered a, you can only address what's in the ordinance and what's
Whether they get something that 100 times or one time, it didn't really have a bearing on what happened before the August meeting, which is what we're here to decide. Does that answer your question, Ms. Dennis?
yes.
Any other questions or comments from the board? Okay, if there are none, at this time, I'll entertain a motion to either approve the denial of the special use permit for the L Hotel, or to grant the revocation, or to deny the revocation of the special use permit.
Mr. Chairman, based upon the evidence presented to the board, I move that the board grant the request to revoke the special use permit issued on July 15, 2021 to Ellen Barbaro to operate church on bed and breakfast at 1040 North Market Street.
A motion has been made by Mr. White to grant the request to revoke the special use permit. Do I have a second? Seconded by Mr. Moore. Is there any further discussion? Seeing no further discussion, we'll now vote. All those in favor, raise your right hand. All those opposed, raise your right hand. The special use permit is revoked.
Mr. Chairman, I would like to give you a report.
So noted.
Okay, well, I just went on the record that we are reelecting the report.
That's fine. You don't perfect your appeal by telling the board of adjustment that you appeal. There's procedural steps that have to occur. And that's not even gonna happen until after the decision is reduced to writing.